On Sunday, June 13, 1971, readers opened the New York Times and found the first installment of a story the government had never meant them to see. The headline pointed to a secret Defense Department history of the Vietnam War. The documents were soon known as the Pentagon Papers. They did not reveal a single battlefield order or one isolated scandal. They showed years of official decision-making, private doubts, public assurances, and widening war. The stakes were immediate because American troops were still fighting in Vietnam. Presidents had told the public that policy was measured, necessary, and moving toward success. The Pentagon Papers showed that inside government, senior officials had often been far less certain. The study traced decisions across administrations, from Truman and Eisenhower through Kennedy and Johnson. It revealed a pattern. Escalation was repeatedly justified in public, even when internal records showed grim assessments and political calculation. The study itself began under Secretary of Defense Robert McNamara in 1967. McNamara had been one of the architects of escalation, but by then the war had become a strategic and moral crisis. He ordered a classified history so officials could understand how the United States had reached that point. The result was enormous. Thousands of pages of narrative and supporting documents. It was not written for the public. It was a record for officials with clearance, the kind of archive that can sit inside the state while citizens debate a war without knowing what the state already knows. Daniel Ellsberg, a former Marine officer and defense analyst who had worked on Vietnam policy, came to believe that the record should be public. He had seen the war from inside government and from visits to Vietnam. By 1969, he and Anthony Russo began copying portions of the classified study. The act was risky and illegal under government secrecy rules. But Ellsberg argued that a democratic public could not judge the war honestly if the official record remained locked away, while officials continued to speak in partial truths. The New York Times received the material through reporter Neil Sheehan and spent months verifying, organizing, and preparing the story. Editors and lawyers understood the danger. Publishing classified documents during wartime invited government retaliation. But the paper also saw a public interest question at the center of the matter. The documents concerned policy history, not troop movements on the next day. They showed how decisions had been made and explained. The issue was whether the executive branch could keep that history secret simply because it embarrassed the government. The First Times installment did not end the story. It started a constitutional collision. The Nixon administration moved quickly to stop further publication. Officials argued that the documents threatened national security and foreign relations. A federal judge issued a temporary restraining order against the Times. That was extraordinary. American law had long treated prior restraint, stopping publication before it happens, as one of the most dangerous forms of censorship. The government was not merely threatening punishment after publication. It was asking courts to silence the next installment. Then the Washington Post obtained material and began publishing too. The fight widened from one newspaper to the press as an institution. Editors at the Post faced their own legal risk, especially because the company was preparing to go public financially. The decision to publish was a newsroom and corporate gamble. If the government could stop one paper, another might continue. If it could stop all of them, the precedent would be larger than Vietnam. The question became whether secrecy claims alone could overcome the First Amendment. The case moved with remarkable speed. Lower courts split and hearings were held under intense pressure. The documents were classified, but the public controversy was visible every day. The government insisted that judges should defer to executive warnings about harm. The newspapers answered that the First Amendment places a heavy burden on the state before it may halt publication. The burden was not satisfied by broad claims of danger. To stop a newspaper in advance, the government had to show something immediate, specific, and grave. On June 30th, 1971, the Supreme Court issued its decision in New York Times Company v. United States. In a short per curiam ruling, the court allowed publication to continue. 6 justices rejected the government's effort to sustain the restraints. The opinions were not identical. Some justices emphasized the near-absolute danger of prior restraint. Others focused on the government's failure to meet the burden in this particular record. But the public result was clear. The newspapers could keep publishing. The ruling did not declare that every leak is lawful, and it did not erase the Espionage Act. Daniel Ellsberg still faced criminal charges. Those charges were later dismissed after government misconduct came to light, including illegal efforts connected to the search for damaging information about him. That later history is important because it shows how secrecy fights can distort the behavior of officials who believe exposure is an existential threat. But the Supreme Court case itself was narrower. Could the government stop the press from publishing before the public saw the material? For the Vietnam War debate, the Pentagon Papers hardened a crisis of trust. Many Americans already doubted official explanations after years of casualties, draft calls, protests, and shifting military claims. The papers gave that distrust a documentary foundation. They showed that the credibility gap was not only a mood or a slogan. It had roots in memoranda, estimates, and policy reviews. Citizens could now read evidence that officials had described risks privately, while maintaining confidence publicly. For journalism, the episode became a defining example of adversarial reporting on national security. The press did not win because the documents were easy, harmless, or tidy. It won because the Constitution makes government carry an unusually heavy burden before it may silence publication. That principle matters most when the story is uncomfortable. A press that only publishes what officials approve is not performing the same democratic function as a press that can test power with evidence. The story also forces a hard question about responsibility. Governments do keep real secrets. Intelligence sources, military plans, negotiations, and lives can be put at risk by disclosure. But secrecy can also protect error, deception, and bureaucratic self-defense. The Pentagon Papers sat at that boundary. They were classified, but they were also historical evidence about a war fought in the public's name. The debate was not simply secrecy versus transparency. It was about who gets to decide when secrecy has become a shield against accountability. The next checkpoint after the June 13th publication was the court fight that followed day by day: temporary orders, emergency appeals, the Post's decision to publish, and the Supreme Court's June 30th ruling. That sequence is why the anniversary matters. The first installment was not just a newspaper story. It was the spark that turned a secret archive into a public constitutional test. More than half a century later, the Pentagon Papers remain a warning about official confidence and hidden doubt. They remind viewers that major policy disasters are often visible inside government before they are admitted outside it. They also remind journalists that evidence matters. The strongest reporting does not merely accuse. It brings records into view, tests claims against documents, and lets the public compare what leaders said with what leaders knew. On June 13, 1971, the presses did more than print classified history. They forced a democracy to confront the difference between national security and political secrecy. The Vietnam War did not end that morning, but the public record changed. A hidden study became part of civic argument, and the courts had to decide whether the government could close that argument before citizens could read it. The answer in that moment was no.